everybody. My name is Krista Richman, and I'm a partner attorney at Ross & Law Firm. As you heard earlier from Adam, I am well on my way to become board certified. And so I'm going to be presenting to you on my portion of the gun laws. And I want to just introduce myself a little bit so you know my perspective while you're listening to me. So I've been practicing criminal defense for the last 13 years. I spent a big majority of that being a public defender for years. And now, more recently, I'm now in private practice. And so I've tried multiple cases, and many involving this 1020 life statute. Anything from misdemeanors up to the most serious major crimes like aggravated batteries and robberies and even homicide. So for purposes of this, it's not going to be involving the misdemeanors, but more the serious felonies. And so I'm going to be presenting to you on this gun law and discussing the 1020 life statute and important aspects for you to know and be aware of when handling cases that involve these types of charges. There's two main concepts that I'm going to be covering in this statute. One has to do with the reclassification of offenses, and the second has to do with the mandatory minimum sentences that may apply in cases like these. I'm also going to add some various tips and examples that I've seen in my experience to help you be aware of things that you should keep in mind if one of these cases comes up in your practice. So to give you an overview, I'm going to be talking about Florida Statute 775.087. This is commonly referred to as the 1020 life statute. It was enacted to address firearm violence, and it mandates the minimum mandatory sentences for certain crimes involving firearms. The statute aims to deter gun violence by imposing the most stringent penalties. So this law was introduced and has been a significant tool for Florida's effort to combat firearm-related crimes. And its purpose is to ensure that those that use the firearms in the commission of a crime face the most severe consequences, thereby acting as a deterrent. So let's get into my slides. Okay, so the first thing I'm going to talk about is the firearms enhancements. Now, the Florida legislature enacted this specific statute to increase penalties for certain offenses if there is a firearm or weapon used during the crime. So, for example, a second-degree felony, which is ordinarily punishable by up to 15 years in prison, could be enhanced to be treated as a first-degree felony, punishable by up to 30 years in prison if a firearm was included. Okay, so here's the specific portion of the statute, and I'm going to be going through parts of the statute, but really breaking it up piece by piece, so that way you can look at each part, and then I will discuss it with you to really break it out, so that way it's more clear. Now, we are now referring to 775.087, and this is subsection 2A. Whenever a person is charged with a felony, except a felony in which the use of a weapon or firearm is an essential element, and during the commission of such felony, you carry, display, use, threaten to use, or attempt to use any weapon or firearm during the commission of such felony, or you commit an aggravated battery, the felony for which you were charged shall be reclassified. Now, on the right side, you'll see how each one is reclassified. Earlier, I gave you the example of a second degree being reclassified as a first degree. Here, this just lays out that a third degree, ordinarily punishable by 5 years, could now become a second, where the maximum would be 15 years. And then also, if it's already a first degree, it could become a life felony. So the maximum could go from 30 years up to a life sentence. In addition to that, the the reclassification is broken up into small parts. So actually, I want to go back to this slide for a minute. So when we talk about except a felony in which the use of a weapon or firearm is an essential element, that's really important because we're talking about specific cases where when the state has to prove the charge and an element of the charge by itself does not already include proving that there was a weapon or a firearm used. That's what we're talking about here. So in those specific types of charges, that's where this could come into play. So it's important to be on a lookout because what we're really talking about is maximum penalties here. It's going to be important to have that discussion with the client so that they know what they're facing as they're making decisions on cases going forward. Okay. Now, this also reclassifies not only the degree of felony, but you'll see it also addresses the level of the offense level, which you would see on a felony score sheet. So, for example, if a crime that is ordinarily a level 6 on a felony score sheet, that could now reclassify as a level 7, which means that at that point, a person would score higher on a felony score sheet, requiring a higher minimum mandatory sentence without any type of downward departure. Now, that's a different minimum mandatory. It's not a day for day under this statute, but that's just with regards to a felony score sheet. Now, who decides if my case is enhanced? Now, what you have to look to determine this is the information. It's very important. Initially, the prosecutor decides whether to charge you under Florida statute section that we've been talking about, 775.0871. If they decide to enhance you, they will list this statute in the information or charging document. Then it'll be for you to look to your case and your trial to decide whether the underlying felony was committed and whether the defendant carried, displayed, used, or attempted to use a firearm during the commission of that felony. That decision will determine whether the regular statutory maximum sentence would apply or if it would then be enhanced. Now, can they enhance my case based on a firearm and also give me a minimum mandatory sentence at the same time? The answer to that is yes. And these are two separate provisions under the statute. So the enhancements that we just spoke about deal with the ceiling of a possible sentence, meaning the maximum sentence. But the minimum mandatory deals with the floor. So both can be charged together, and therefore, if you commit a specified felony with a firearm, both the ceiling of your possible sentence and the floor of your possible sentence go up. So in other words, the state can reclassify the charge, which increases the maximum, and file it as a minimum mandatory offense all at once. Okay, so one of the practice tips I would want to give you here is when you see an information that is charged that way, you should operate in your trial strategy as if the maximum applies when advising your client about the risks of taking it to trial or not. Meaning, you talk to your client and you explain that if this case goes to trial, worst case scenario, the jury makes the appropriate findings as outlined in this information, you're facing the top maximum. Additionally, a great way to negotiate your case for a reduced sentence is to find problems in the state's case that would show how it would be extremely difficult for the state to prove the firearm was used or impossible for them to prove. Because you got to keep in mind that the prosecutor has the power to change the charge or reduce charges and to get rid of enhancements or imply enhancements via legitimate uncoerced plea bargains. So looking for ways to attack evidence is extremely important when we're dealing with this. Now, turning to the next slides. The statute requires a judge to sentence a person convicted of a specified offense to a mandatory minimum term of imprisonment if, while committing the offense, the person possesses or discharges a firearm or destructive device, or if the discharge results in death or great bodily harm. So now we're moving on to the minimum mandatories portion. And this is how the statute begins. Now, if your client is charged with a specified offense from this section and they're outlined here, then this is how you know you could potentially be looking for a firearm enhancement to apply and also a minimum mandatory to apply. So it would be in cases where somebody is charged with murder, sexual battery, robbery, burglary, arson, aggravated battery, kidnapping, escape, aircraft piracy, aggravated child abuse, aggravated abuse of an elderly person or a disabled adult, unlawful throwing, placing, or discharging a destructive device or bomb, carjacking, home invasion robbery, aggravated stalking, various trafficking in cannabis, cocaine, and other controlled substances, possession of firearm by felon, or human trafficking. So when you see these charges and any allegation that a firearm is used, the red flags and radars should go up. I can tell you in my time of practicing in these types of cases, the most common ones that I see are with regards to murder, robbery, burglary, aggravated battery, and possession of firearm by felon. Not that the other ones can't also be enhanced or added to. I'm just saying that over time, I think that those are the most commonly seen throughout my practice. Okay. So the term minimum mandatory penalty used above is a period of incarceration in Florida State Prison that must be served. In the event that a minimum mandatory is imposed, the person convicted must serve a minimum amount of prison as specified. The person is not eligible for gain time or early release and would have to serve every day of the minimum penalty. So, as a practice tip, when we're advising clients about minimum mandatory penalties under this statute, this would be a day-for-day sentence. You can't get good time, gain time. No time comes off of it when you go forward. That is specifically outlined in this statute. We know as defense attorneys that often if someone goes to prison, then with good time and gain time, their prison sentence can actually be reduced. Now, if you're sentenced to prison under this statute, there is no good time or gain time. So it's day for day. And that's really important because it's common for clients to try to calculate their good time and gain time when they're considering plea bargains and whether or not they want to go to trial with regards to what they're facing. Okay, now another tip. So the mandatory minimum sentences can make plea negotiations more complex because prosecutors can often leverage these minimum mandatories to encourage defendants to plead guilty. And it's crucial to understand these minimums when you're advising clients and negotiating plea deals, because a prosecutor has the discretion to say, well, I will give you an offer that does not include this minimum mandatory as a plea deal. But you would have to advise your client that if you don't accept that plea deal and you were to go to trial and then be convicted as charged and the jury made the appropriate findings, then this minimum mandatory would apply. And at that point, once you're at sentencing, the judge does not have discretion to then waive that minimum mandatory, just like the state could prior to going to trial. So Under this statute, the judges have limited discretion in sentencing anybody. If these mandatories apply and all of the criteria was found at trial, the judges are bound to give that. There's only some exceptions. For example, if somebody was convicted of a 1020 life crime and they had a mandatory minimum after trial, the judge could potentially get through the minimum mandatory if the defendant qualified for something such as a youthful offender sentence. Now, that's a specific downward departure where somebody has to be under 21 before they committed the crime. At the time that they committed the crime, they would have to be under 21. And there's other criteria that the court would have to find too. But it would be one exception where the judge could have the power to actually give something less than the minimum mandatory, but again, wouldn't have to. But without meeting all of that criteria, otherwise the court could be bound. So it's a good practice tip to have that in mind when you're talking to clients and encourage them to think about different plea deals and what you can negotiate prior to trial, and then what you'll be left with if you don't when it comes to sentencing post-trial. Okay, so now moving on to the 10-20 life actual mandatories. The mandatory minimum assessed depends if, number one, the person actually possessed the firearm during the commission of the offense, or two, discharged the firearm during the commission of the offense, or three, discharged the firearm during the commission of the offense and caused great bodily harm or death. Okay, so as we like to refer this as 10-20 life. So in the event that one merely possesses a firearm during the commission of the offense, one of those specified offenses that we just went over earlier, the mandatory minimum penalty for that offense is 10 years incarceration in Florida State Prison. In the event that a person discharged the firearm during the commission of the offense, the mandatory minimum penalty for the offense is 20 years incarceration in Florida State Prison. And then finally, in the event that one discharged the firearm during the commission of the offense and result in the discharge was death or great bodily harm, the mandatory minimum penalty for the offense is 25 years incarceration and can be up to life. Now, this is important to understand how this would apply to the facts of your case. So when you're looking at, for example, a robbery case, the things that you're looking at is to see in the information if they're alleging that the person was in actual possession of a firearm at the time of the offense, or are they alleging that the person discharged, meaning that a gun was actually went off and there was a shot that occurred, which would be the 20 years, or if there was not only a shot, the gun was discharged, but a person was actually hit with the bullet, and then there was great bodily harm as a result or death. That's when you get up to the 25 years. And so again, you're going to look to the information as charged and outlined because that's what the state has filed to put us on notice of what they intend to prove. And then you're going to look to the facts of the case to see whether or not they can actually prove that. Now, in this statute, there is a specific portion of the section that discusses a minimum mandatory sentence of 3 years instead of the 10 for the mere possession of the firearm by a felon or burglary of a conveyance if the possession occurred during the commission of the offense. So for those two specific offenses, meaning possession of firearm by felon and burglary of a conveyance, instead of the minimum mandatory applying for being in actual possession being 10, like it would be for all those other offenses that we just went over. In these two specific types of felonies, the minimum mandatory sentence would be 3 years. And I can tell you that possession of firearm by felon, when a felon is alleged to have been in actual possession, meaning it was on his person, touching him or her, then the 3-year minimum mandatory sentence applies. This is a very common case that I've seen throughout my 13 years going forward. And the biggest thing is always, are we talking about actual possession, meaning that it's on their person, actually physically touching them, or are we talking about constructive possession where it's just near the person? So for purposes of this, the possession, as it's defined, is kind of what I just explained. It's defined as carrying it on the person. Possession may also be proven by demonstrating that the defendant had the firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the offense, if proven beyond a reasonable doubt. So that second part is in the statute, and you should definitely be aware of it. I can say that I have not seen that part used as much. It's usually pretty clear from the facts whether or not someone is holding it or has it on their waistband or on their person versus not. But just know that it's also in the statute, so you should be aware of that. Another important to note is with regards to the actual cases themselves when we're looking at the facts. And when we're attacking that, what are things that the state would be using to prove that somebody had a firearm during the commission of this crime? So, for example, one could be the physical evidence itself. Was there an actual gun recovered, right? And then besides that, did somebody see a gun? Did somebody hear a gun? Did multiple people see or hear it, right? Is there other physical evidence of a firearm? So like was the firearm itself recovered, but is there any physical evidence related to a firearm? For example, a gunshot wound, a bullet fragment, casings, or things like that also found at the scene and involved in your case. Another thing could be if the firearm was recovered, was it tested for DNA? Was it, did they try to do latents and fingerprints on the firearm? These are all different ways to try to see what evidence the state has or what you could expect the state might have or argue that they don't have and they should have when you're defending this case with regards to the actual firearms. Additionally, sometimes I've seen cases where portions of it is on video. Can you tell that the quality of the video if someone's holding a firearm or some other weapon? Is there photographs, right? So all of these are really important things to think about when trying to actually fight whether or not there was a possession of a firearm that was used in the commission of these crimes. Another important thing to note on the firearm being recovered is that in these types of cases, and this was very surprising to me when I first started working on these cases, that somebody can be charged with a 1020 life firearm type charge, and the state doesn't have the firearm recovered, that there's no firearm in evidence, and could still potentially be subject to the minimum mandatories in this case. And so again, where you would have to look at is what can the state prove? So testimonial evidence. If a witness in your case says, I saw a firearm and describes the firearm and says the person pointed it at him and so on, and the jury fully believes that, then someone could be convicted of a crime. And so that's why, again, it's important to make sure you fully go over all of these things when you're looking at your case and trying to determine what the state can prove with regards to the minimum mandatories. Okay, so proving actual possession of the firearm. To impose the 3-year minimum mandatory sentence after trial, the judge in a bench trial or a jury must make a specific finding of actual possession. The special interrogatory verdict typically asks whether the defendant did or did not actually possess a firearm during the commission of the offense. At trial, the special interrogatory is a mandatory prerequisite to the 1020 life enhancement because the enhancement requires the jury to find facts different from the facts necessary to convict of the underlying crime. And so, for example, in these cases, you would be looking to the verdict form. And just to give you for instance, a verdict form might say something along the lines of this. As to count 1, we find the defendant, and there'll be an option that says guilty of, let's say, robbery, as charged in the indictment. And then right underneath that, there'll be something that says, if you find the defendant guilty of robbery, you must then also determine whether the following 4 questions have been proven beyond a reasonable doubt. And then they'll be numbered, questions 1, 2, 3, and 4. And they'll be as follows. Did the defendant commit the robbery with a firearm? Yes or no? Question 2. Did the defendant actually possess a firearm? Yes or no? 3. Did the defendant actually discharge the firearm? Yes or no? And then 4, did the discharge of the firearm by the defendant actually inflict death or great bodily harm upon the victim? Yes or no? And then the last option, of course, would be not guilty. So in cases like this, you would be looking at a sentencing to determine what the jury found by answering those specific interrogatory questions. So in the example that I just gave, if a defendant committed the robbery with a firearm and actually possessed the firearm, that's where we'd be looking at a minimum mandatory. The first one could be the 3 years, could be the 10 years for possessing it during the commission of the crime, depending on what the charge is. Now, so in robbery, we'd be looking at 10 years. Now, did the defendant actually discharge the firearm? If the answer to that was yes, then discharge, as we've previously talked about, would be 20 years. That would be the minimum mandatory. Or 4, did the discharge of the firearm actually inflict death or great bodily harm upon the victim? The answer to that is yes. Now we would be looking at the 25-year minimum mandatory. And so that's what would need to be proven and found by the jury so that those would apply. Okay. So even if the minimum mandatory terms of imprisonment imposed pursuant to this section exceed the maximum sentences authorized by the Criminal Punishment Code, then the mandatory minimum sentence must be imposed. What that means is that if somebody scores, say, 3 years at the bottom of their guidelines, right? That would be originally under the Criminal Punishment Code what somebody would score. However, if the mandatory minimum sentence is higher than that, meaning say the minimum mandatory case, minimum mandatory associated with the case was 25 years, then the minimum would be 25. It would not be the criminal punishment code guideline sentence. Now, if the mandatory minimum terms of imprisonment pursuant to this section are less than the sentences could be imposed, or the criminal punishment code under this chapter, then the sentence imposed by the court must include the mandatory minimum sentence of imprisonment as required by the section. So going back to the same example with the score sheet and the minimum mandatories. Now, if the minimum mandatory in the case is 10 years, but the person scores 12 years. Now we would be talking about the minimum sentence being 12 years, not 10, because the minimum mandatory would apply. But we would be looking at the first 10 years being day for day, because the minimum mandatory would still apply even though the criminal punishment code mandatory on your guidelines would be higher. So basically a person like that would be sentenced to 12 years. He would have to do the first 10 of it day for day. And then after that first 10 under 1020 life portion was served, then he would be looking at the remainder of the 2 where he could be eligible for that discretionary good time and gain time that we had talked about. And so that's what this means when it says that the minimum mandatory will be applicable. So the minimum mandatory it always applies. It's just a matter of if it's more than what you score, then you're going to defer to the minimum mandatory and it's going to be day for day. But if it's under what you score, you can still get more than a minimum mandatory, but you got to know that the minimum mandatory portion will still be served day for day, no matter whatever your sentence. Another provision of this statute is that notwithstanding 948.01, adjudication of guilt or imposition of sentence shall not be suspended, deferred, or withheld, and the defendant is not eligible for the statutory gain time or any form of discretionary release other than pardon, clemency, conditional, and medical, all of that. So in these types of cases, you cannot get an adjudication withheld. Now, why? And this is important because they put it in the statute and they talk about the statute's intent and the legislative intent behind it. It's the intent of the legislature that offenders who actually possess, carry, display, use, threaten to use, or attempt to use firearms or destructive devices be punished to the fullest extent of the law. And the minimum terms of imprisonment imposed pursuant to this section shall be imposed for each qualifying felony count for which the person is convicted. The court shall impose any term of imprisonment provided for in this subsection consecutively to any other term of imprisonment imposed for any other felony offense. Now, that's some serious language in there. This tells you that this is for the most serious of crimes, and it's the legislative intent to punish people convicted under this the most severely. We saw consecutively and no gain time, and they want it to be fullest extent of the law. Okay, so I want to go back a little bit and make sure that at the beginning, when we were talking about when a weapon or firearm is an essential element of a crime, when it applies and when it doesn't, and give you a specific case example, because this can get a little bit complex. So in my example, I'm going to talk to you about aggravated battery and how it can be proved in multiple ways. So if you look at the aggravated battery statute, which I have put up here on the slide, it says 1, a person commits aggravated battery who, in committing battery, bodily harm, permanent disability, or permanent disfigurement, or weapon. Okay. And then the rest of it is in there too about the battery on a pregnant person and so on, but that's not what's important for purposes of this example. Now, a person who violates this section, so an aggravated battery, as you'll know, is a second-degree felony. So the maximum that someone is facing on an aggravated battery is 15 years in Florida State Prison. However, you're going to need to look how this is charged in the information. And that way you can determine whether or not the weapon or firearm is an essential element of the crime. So going back, there's two ways to prove this, right? Great bodily harm or deadly weapon. So in an aggravated battery that's charged ag-bat great bodily harm, right? In order to prove that, there is no weapon or firearm as an essential element of the crime. Now, if the charge is aggravated battery firearm, then a weapon or firearm is an essential element of the crime. So what that means is that if, just move on, here we go. Yeah. So what that means is if an aggravated battery, great bodily harm is there, then that could be reclassified under the reclassification portion of this statute to a first-degree felony if a firearm is then used. Now, if the charge is only aggravated battery with a firearm, then it could not be reclassified and it would remain as a second-degree felony. So now I want to talk to you a little bit about some tricky examples and complex examples of when we see this happen. So for example, what if you look to the information and it says aggravated battery, great bodily harm / firearm? So then the first questions you're looking at, what degree felony is this and why? Is this a second-degree felony or is this a first-degree felony? Well, we need to break it down and go over exactly what I had just broke down about whether or not this involves the state proving an essential element of the crime being a firearm or a weapon. So in that example, it's actually both great bodily harm and a firearm. Because it's both, this would be reclassified to a first-degree felony because a jury could find that somebody committed aggravated battery by causing great bodily harm. And there was a firearm. Now, there could be a min-man opposed in this case, in addition to the reclassification, as I spoke about, because we're talking about the maximums now being first-degree felony, and the minimum mandatory could be imposed as well under the 1020 life portion on whether somebody discharged the firearm, could be 20 years. Actually hit somebody and caused injuries, could be 25. So again, you would have to look to the information, to the facts of your case, and what could actually be proven. But in that scenario, that could be reclassified as a first-degree felony because there is a way for the state to prove aggravated battery, great bodily harm, and that would not include an element already of the weapon or firearm, and now we're adding the firearm to it. So now it's reclassified. Now, as to the next example, what about if the charge in the information is just aggravated battery with a firearm? Then what degree felony is that and why? So in that example, that would be a second-degree felony. Why? Because aggravated battery, again, could be two different ways, great bodily harm, but we see no mention of that. It's or deadly weapon. So here it's deadly weapon. So to prove aggravated battery with the firearm is your firearm or deadly weapon, and it's part of the elements that the state would already have to prove. So therefore it would not be reclassified and would remain a second-degree felony. Now what min-man would apply? Again, you'd have to look to the facts of the case to see what they're alleging. If they're alleging only mere possession, or if they're alleging that there was a discharge and or if they're alleging that there was actually a discharge plus great bodily harm and or death. Okay, now some practice tips to go with this. So when we're looking at these types of cases and how we can fight them, a lot of them are very fact specific. And you're going to need to refer to, again, start with the information, start with your maximums, look for your minimums, and operate on that assumption going forward. Then you look to the facts of the case to determine how you can fight them. And now there's two different ways that we like to challenge cases like this. One of the first ways is that we like to find a legal basis to convince the state why they cannot prove, or it would be very unlikely or difficult for them to prove the elements that they need to prove to do the enhancement, to prove a firearm was used in the case. The second way is that you can also look to mitigation in order to try to convince the state to waive any minimum mandatories or enhancements and negotiate a good resolution. In these types of cases, while the statute mandates minimum mandatory sentences, judges as well as prosecutors can consider mitigating factors in these individual cases and circumstances. So, for example, if a defendant's actions were driven by coercion, or if the firearm was discharged accidentally, these are factors that could potentially influence the court's decision or impact sentencing outcomes. So when you're trying to negotiate these cases and talk to clients about them, it's important to look for mitigating factors as well as legal bases why things cannot be proven or it would be difficult for them to be proven. Further, it's important to make sure that you look at all the case law and try to find any case law that it closely resembles the facts that you have to work with in that specific case, because the case law illustrates how the courts interpret and apply this statute. So this presentation was based on the overall statute and what specifically it says, but the case law can give specific examples when you really get into the nitty-gritty portion of it. And how it's enforced. And it can also give you insight as to great arguments that have been successful in challenging or mitigating the application of this statute. In addition to that, it's important to stay updated with any of the recent legislative changes and the court's rulings that may impact how the statute is applied. There's shifts in interpretation or amendments to the law, which can influence both the prosecution strategies as well as the defense strategies. So it's important to be current on the law and the application. And so an important thing when we're dealing with these cases as well is to talk to your clients about all of the implications that could potentially happen. Kind of like the way I've been teaching about this statute during this presentation is similar to the way I'd present it to clients as well, because they need to understand what they're risking if they're going to take the case to trial, or what they're risking if they're going to reject a plea offer, and all the different ways things like that can go. So it's essential to clearly communicate with clients about the implications of this statute. And clients should understand that the statute imposes severe minimum mandatory sentences, but then also the importance of the evidence or arguments that may influence their case. So this has taken us back to the different types of evidence and how the state would be able to prove that there was a firearm involved in this type of case. And, is this the type of case where there's a ton of evidence that seems to be overwhelming? Like it's on video, multiple people saw it, multiple people heard it. The firearm was recovered. There's DNA, somebody's injured. And so all of these things can affect the seriousness of the case. And then also like where you would be at with regards to resolving it before trial and before you're ultimately looking at these harsh minimum mandatories and very severe, lengthy sentences. Now, so I guess to summarize the key points that we've gone over, this statute is to impose the most severe sanctions with regards to minimum mandatories and reclassifying offenses to make them even more serious than they ordinarily would be. And so understanding different tiers of these penalties and the statute's impact on defense strategies is crucial for effective legal representation. Okay. One question I have is, are there any exceptions or specific scenarios where open carry might be permitted? So in these cases that I've been talking about, it's not necessarily so much about the open carry, because remember at the beginning when I talked about for these cases to happen, there has to be a specific crime. So it's not, if you're just having a gun that's out in the open, right, that would not be one of the enumerated offenses that this statute would apply for. So remember in the beginning when I said, and I can read it again, any person who is convicted of a felony or an attempt to commit a felony, regardless of whether the use of weapon is an element of the felony and the conviction was for, and then I went through all of those very serious charges, meaning murder, sexual battery, robbery, burglary, arson, and so on. And then the statute continues and says, and during the commission of the offense, such person actually possessed a firearm or destructive device, as those terms are defined in the statute, shall be sentenced to the following minimum mandatories. And then it's either the 10 years for a person who just possessed it, it's the 20 for the discharge, 25 for the discharge plus great bodily harm or death. Okay. I have another question here. How do you challenge a risk protection order and what evidence is needed to contest one? So that will be addressed by my partner, Susan Lawson, because her presentation that goes after I present is all about the risk protection orders. And that would be a great question for her to ask. That's outside the scope of this one. So I'll move on to the next one. Okay. How should attorneys advise clients who are subject to a risk protection order, particularly in relation to their firearm rights? So again, I would direct that one. I think that would be a great question for Susan when she's talking to you all about the risk protection orders, because that's part of her presentation. Let's see if there's some more. What are the current legal implications for individuals with a domestic violence restraining order under federal and Florida law? Okay, so this question is definitely outside of what this presentation was about, but I can tell you that just because our office also handles domestic violence injunctions in Florida, I don't do the federal portion of it, but just the domestic violence injunction in Florida, the person cannot have any firearms. But anything beyond that, I would say that, again, is outside the scope of this. Okay, and then next question. How does the stand your ground law affect the burden of proof in self-defense cases? Okay, so that's a great question. So we're talking about defenses in this case. And so, yeah, so anytime that there is a self-defense claim, you would be looking at the self-defense, which would be the justifiable use of deadly force if we're talking about firearms, and because firearms are considered deadly force. And so you'd be looking at that statute to determine if how the firearm was used in this case would apply as self-defense. Again, this would be very fact specific as to what would have to be shown and proven, because the state has the burden of proof to go forward, both at the stand your ground as well as at trial. They have the burden of proving that this was not self-defense. And so I guess the way it would be affected is basically a stand your ground motion is a pretrial motion that you have before you go to trial. If you're not successful at that motion, then you still have the option of going forward at trial and raising self-defense as an affirmative defense, where you're saying, yes, I did what you're saying, but I'm justified because it was in self-defense. When you bring firearms into the scenario and it involves the use of a firearm, the threatened use, or the actual use, now we're talking about the deadly force provision. And so they're two separate, like one is a pretrial motion hearing and one is a trial, but in both cases, the state has the burden of proof. It was a pleasure to instruct all of you and inform you about all the different nuances and things that come up when you're dealing with firearms and the 1020 life statute and reclassification of offenses.